And Washington County Quorum Court is now called into session. Good afternoon or good evening. Let's go ahead and get kicked off. J.P. Duncan, will you lead us in the prayer and pledge?
Please stand with me and bow your head. Father God, thank you for the opportunity to serve the county. God, I pray that you'd give us wisdom on the court. God, I pray our decisions would be pleasing to you. God, I pray our discussion would be pleasing to you. Father God, we're thankful. God, thank you for your son, his life, death, and resurrection. Lord, we pray these things in Jesus' name. Amen. Amen.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, thank you, J.P. Duncan.
I move adoption of the agenda.
We got adoption of the agenda, motion to adopt the agenda. And a second. All in favor? Aye. Those opposed? All right. Any preliminary motions as you chew on your...
I would move that we read the ordinances by title only.
I have a motion and a second to read by title only. All in favor? Aye. Those opposed? Okay. Citizen comments. We'd like to invite the citizens of the county to come and visit with us, share some observations in the county, things we would like to share, good, bad, and everything in between. Come on in. Come on up. Tell us who you are and where you're from.
My name is Daniel.
Push that button in there. There's push the button in.
Volcano Road, which is a branch of...
There you go.
My name is Daniel Marzoni. I live on Volcano Road, which is a branch of Trace Branch Road. Unfortunately, I'm here to complain about the road department. The road department over the past 2 years has done a great deal of preparation to get the Trace Branch paved. We were told by letter that we were first priority at the beginning of this year, and I'm well aware that the road department has had to do a great deal of repair from the floods. We are well aware of that, but we have not seen the road department since, I believe, it's April, with the road department, the grader, gave us a lick and a promise after the floods. The quarter mile right on Trace Branch to the west, where it meets Wallen Mountain, has been severely washboarded. And that, to me, is that the grader was going too fast. We are frustrated with the people on the road. We're not happy. I personally gave up an entire row of trees. I have a quarter-mile frontage on Trace Branch, and I gave up trees that I loved because it did to Trace Branch a tunnel. And I gave up those trees so we could get that road paved. So the gist of what I'm saying is that we have a number of people on Trace Branch who are not happy that we have not been, that the promise and the priority one, which we were told, has not been followed through. Thank you.
Thank you, Mr. Marzoni. Thank you.
Well, this is Lynn Marzoni, his wife. We have lost a lot of people due to health issues because of this road. And I have Wendy Boswell here, who'll be speaking after me. She started the petition mainly because we've lost some wonderful citizens who had to move because of the dust. Now, since they have improved the road, traffic is crazy. We have a lot of increased traffic. And people are selling their houses now. We're losing citizens. I did call the judge, and I asked him to look into it, and I never heard a response back. But anyway, like I said, we just need to know, we would like to be back on priority one. And we've seen other things happen on Smoky Bear Road. We also saw that it got chat and gravelled. And we're going, wait a minute, we were priority one and they were not priority one. So just give us some answers and an agenda and a schedule if you can. Thank you.
Thank you.
I'm Wendy Boswell. My husband Jim and I are here to discuss Trace Branch Road, Wallen Mountain Road, Washington County 32. I've been in contact with Charles Ward, road superintendent. He's done an awesome job. I know that the last time I spoke with him, it was mid-May, and there have been 2 flooding events since then. Back in mid-May, he said that they would be back on the road because I called because they had removed the construction equipment, and they said they'll be back in about a week. So I didn't even contact them until after August 1st. I thought maybe I'd get an update on a plan and timeline. When I talked to the office managers, they said that they would give Chief of Staff Gales and Road Superintendent Ward messages. I never heard back from either of them. And what I'm requesting, please, is we received something right around February 1st that there was a plan, a proposed road, paving, and we had heard that it was going to be asphalt, not chip and seal, but asphalt. And we've checked up ever since then, and I find the lack of communication is my main issue. I would truly appreciate to know the plan and timeline. I was assured that it is on the list, but I'm not assured that it's going to happen this year, that they'll do their best, but I would really appreciate a plan and timeline. We went out to Irvin Beeks Road, which was paved, I think, last year, and that's when they told us that we would be the next road, that we were top priority. So I have a whole stack of communications that we've made, but lack of communication from the road superintendent, even with leaving messages. It's just very disappointing, and I would think that with that amount of money, there would be some way that you could provide the citizens some communication or the plan and timeline for when we could expect that work to be done. They've done a tremendous job improving our road, but it's been since mid-May since they've worked on it, and quite frankly, it's been deteriorating, as the Marzonis have said. We appreciate all the work that they do. Just, I'm asking for a plan and timeline for when it's going to get done this year.
Thank you.
Thank you.
Public comments.
My name's Frank Mayfield. I live at 980 Rocky Lane. That's a rural Fayetteville address. And I followed very closely the discussions and votes on the jail, and was delighted that you all made a good decision on studying the jail and our judicial system so that we can make informed decisions on getting people off the floor for less than $38 million. I hadn't heard anything about the request for proposals. I've been looking in the paper. I didn't know where that stood. I know that when that funding was passed, there was a great sense of urgency that we might not have the luxury of 6 or 8 months to make a study. So I hope that same sense of urgency is still present, and that we'll hear soon what the request for proposals will be. Thank you.
Thank you. Public comments. Public comments. All right, thank you. Item 6, approval of the minutes. Entertain a motion.
Hey, sorry, I move approval of the minutes.
Approval of the minutes, a second. Any corrections, minutes? All in favor? Those opposed? All right, minutes approved. Judge report, you have in your packet a county disposal report, and the only other piece I wanted to share was that last Friday, Well, I guess it was earlier this week, Monday or Tuesday, the Northwest Arkansas Crisis Stabilization Unit sent their first report into Department of Human Services in Little Rock. Ozark Guidance, they put all the data together. They run our facility. They are our medical service provider and partner, and they provided that information and report to Little Rock Monday or Tuesday. They did meet with the advisory board last week just to kind of give a sneak preview of what they will be submitting. And going forward, the Jails and Courts Committee, the Jails Committee will be providing that report, so the jail committees would be able to see that report going forward. But the first one was submitted this past Monday, Tuesday. Really pleased with it. I think there was an article put in the paper by the Democrat Gazette, Mr. Sissom, and I think pretty much everybody was really pleased. I think we had 21 referrals, and so they were really excited about the fact that, again, people are now starting to use it as the word gets out. We'll continue to see that uptick. I think the goal is to have anywhere from 1,000 to 2,000 people go through that, through the crisis stabilization unit within a year, and so that's that target. My expectation would be that it'll be right there to 1,500 to 2,000, which means there'll be 1,500 to 2,000 people that are not in the county jail and getting the long-term support and care and help that they need with their mental concerns. So anyway, really pleased with that going out there. And that's what I have that I wanted to share on the judge's report. Item 8, we have consent agenda.
Mr. Chairman,
J.P. Madison.
thank you, Mr. Chairman. I was just curious, the report on the crisis stabilization unit that went to DHS, does it give the daily occupancy or a head count?
Yes, I can send that to you so you can make sure
Well,
you see that.
I was wondering if you might send a copy to all of us.
That's what I'm
the
saying.
daily
I'll send
occupancy,
it to JP.
along with the expense so far to the county.
I'll send that.
Okay, thank you.
Go ahead, Counselor.
On the consent agenda, item number 6 is the ordinance for the additional revenues of $31,167. After you pass this through Finance and Budget, there was, I think, JDC recognized they had left an item off, and there needs to be added to that. The total appropriation is correct, but in the line items in Article 2, there should be an addition for meals and lodging in line item 3094 for $1,000. The total appropriation will not change, but just need someone to amend. We'll need to amend Article 2 to add that meals and lodging $1,000 line item.
J.P. Madison.
I would move to pass the consent agenda with the amendment recited by our county attorney.
All right, so we have a approval to approve the consent agenda with the amended $1,000 that the council just talked, and the second by J.P. Pine. Any discussion?
I need to read first.
Oh, go ahead and read yeah, I'm going to read all 6 of them.
I do have to read all the titles real quick, sorry. Item 1 on the consent agenda is an ordinance changing the title of Maintenance Technician 2 to Maintenance Technician Lead Trainer in the Buildings and Grounds budget for 2019 and appropriating $1,171 to the Buildings and Grounds budget for 2019. Consent agenda item 2 is an ordinance creating the position of Administrative Assistant in the Juvenile Detention Center budget for 2019. Item 3 is an ordinance appropriating $21,800 from unappropriated reserves to various line items in the Circuit Court 2 budget for 2019. Item 4 is an ordinance anticipating revenues totaling $358,731 in high-intensity drug trafficking areas, the HIDA grant fund, and appropriating $358,731 from the HIDA grant fund to the HIDA 2019 G19 GC 0004A budget for 2019. Item 5 is an ordinance recognizing revenues totaling $732.39 in the general fund and appropriating $732.39 from the general fund to various line items in the grants administration budget for 2019. Finally, item 6 will be an amended ordinance recognizing additional revenues or an ordinance with the amendment, recognizing additional revenues of $31,167 in the JDC Grant Fund and appropriating $31,167 from the JDC Grant Fund to the Juvenile Detention Center Grant and Aid 2019-2020 budget for 2019.
All right, so we have a motion, we have a second. Any discussion? Any discussion? Public comments? Any public comments? All right, Ms. Patty?
Willie Lemming. Yes. Ann Harbison. Yes. Butch Pond. Yes. Lance Johnson. Yes. Susan Cunningham. Yes. Harvey Bowman. Yes. Judith Yanez. Yes. Patrick Deakins. Yes. Lisa Ecke.
Yes.
Sam Duncan.
Yes.
Eva Madison.
Yes.
Andrea Jenkins.
Yes.
Suki Hires.
Yes.
Sue Madison.
Yes.
Okay, the consent agenda items pass. Item 9, ordinance appropriating $24,000, J.P. Harbison. Council, will you go ahead and read the ordinance, and then you can go ahead and introduce it after he reads it.
An ordinance appropriating $24,518.50 in the Quorum Court budget for 2019.
This money was for the Johnson Control Project. It was the bond, where they utilized this company to do the bond issue. Okay. I move that we pass 9.1.
Second.
Got a motion, a second. J.P. Madison.
Thank you, Mr. Judge. I'll be voting against this tonight. This was a project well in the works before this budget year. It's beyond me that we would choose to enter into a multi-million-dollar energy savings project over the course of many years and not tell the court that it was going to cost $25,000 in lawyer fees ahead of time and not make an attempt to budget for that. There's been no explanation beyond that as to what the actual nature of the work was. We received 2 non-itemized bills, one for $17,000 for lawyer fees, and it was a one-line bill. The next was for attorney's fees for a bank in Missouri, which I can't understand how we're paying that. So this was a project that the Quorum Court pushed ahead with last year, that our Buildings and Grounds Department brought to us and that we approved. But it's beyond me that we're paying $25,000 for unexplained lawyer fees after the fact. So without any additional information on why this expense is falling on us and falling on the Quorum Court's budget for a Buildings and Grounds project, I'll be voting against it.
Any other discussion? J.P. Duncan.
I think, we have to pay our bills. We're going to get sued if we don't pay this bill. So to me, I think it'll cost us more money in the long run if we don't we owe the money. They issued the bonds, so they did their work. It's a bill we have to pay.
Any other discussion? J.P. Madison.
Thank you, Mr. Judge. I also have problems with this. It seems to me that it certainly should not come out of the Quorum Court budget. We played no role in picking the attorneys or dealing with the attorneys. I'm at a loss as to why it's coming as a bill to us. Thank you.
Any other discussion, Council?
So there were some questions at the Budget and Finance meeting. I've got some clarification for you. We did sign agreements for, the engagement agreement that we signed with the Wright Lindsay firm was a flat fee, $17,000 engagement agreement. The reason that this didn't go, typically this would have gone into the finance, which means you would have been financing the $17,000, so it probably cost you more like $20,000 over the term of the loan, but it would have gone in. The problem was the amounts weren't known at the time, the total amount at the time that you passed the ordinance, and we didn't even know this at the time that you passed the ordinance, and the ordinance was published and posted. In order for us to go back in, and I talked to the attorney about it today, in order for us, for the county to go back in and add these fees, we would have had to republish the notice, and we'd had to redo the bonds. The issue with the bond was the bond rate we got from this particular bank is going to save the county, I believe, I don't remember, I think we talked about it, $250,000, $500,000 or something over the, life of the loan. And so had we gone back and republished that and included those fees, we would not have gotten that rate. Because that bank then knew what the other bank's interest rate was and would not have, they would have had to republish and had to resubmit all the bids. And that bank, most likely, seeing what the other banks had done, would not have come in that low, I don't believe. And so that was the reason for this, and the agreement that we signed with the bank on this that did the loan stated that the county would pay that fee, the bank's fee, the attorney's fees on this as well. And so that's where the $25,000 came from. And I don't think that was known at the time, because when we published the ordinance, we hadn't selected a bank. We hadn't gotten any bids. And so you couldn't go back in and add that after the fact. But considering that it was, a total of $25,000 versus a savings of $500,000, then it just didn't make sense to go back in financially and redo this, because we'd just be adding to our debt. So that's the answer on it. We did agree to pay these. I do have that. So I just wanted to let you know that this isn't just it's not being stuck with it after the fact. That was kind of part of it. And the bond counsel that prepared all the ordinances and the loan documents was Wright Lindsay, and so we agreed to pay their fee when they got involved, because we didn't have a choice. We had to get bond counsel on it. So,
J.P. Ecke.
Thank you, Judge. Refresh my memory, if you would, Counselor, please. We had an emergency quorum court meeting in order to pass this ordinance to save the county money, because the bond company says, or the bank said, if you don't accept this within a certain amount of time, we will withdraw that interest rate and it will cost you a lot of money. So everybody on the court at that time was informed about the fees and what happened and why it happened, because we had an emergency meeting and we had a discussion on this, correct?
That's correct.
that's correct. The court voted to proceed with the Johnson Controls project, which meant to publish in order to get the bids on the bond. Once that happened, the bond, the proposals that came back, all the banks really said, this offer is good for 30 days. Well, we weren't going to have a quorum court meeting within 30 days, so we had to call a special quorum court meeting. We actually got permission from them to give us 45 days because we had to get a quorum court meeting, and then we had to wait 30 days before we could close due to our publishing requirements for anything that you pass, any law that you pass. And so they gave us that extension, and we had a quick meeting to approve the financing of the project. And so the project amount that the quorum court was given initially was correct. The only thing was, because we had already published the legal fees were not tied into that, or we wouldn't be having this discussion at all. And it is unfortunate that it happened that way, but there wasn't really anything to be done about it at the time, and I honestly, it wasn't anything that popped up on my radar to say, oh, by the way, we're going to have to pay out of pocket because we've already done this, because that issue really didn't come up until later, after we'd already approved and everything like that.
That's right. J.P. Deacons.
One more question, County Attorney Lester. Can you shed some light on why this particular law firm was chosen to do this particular work?
This law firm was chosen because this particular law firm had done this type of bond work, and this, like I was telling you at the Budget and Finance meeting, this is a relatively new law in Arkansas and within the last couple of years that was passed for these types of financing projects, so that allowing a county to be able to finance a project like this without having to go to the voters and pass a bond issue. And so this is a special financing vehicle in Arkansas law that had previously only been available to public education and higher education. Right. And so the legislature changed that to counties and municipalities, so that the counties and municipalities could enter into these energy savings contracts without having to go through the whole bonding process. And so there's a small cutout exception on the funding, so that you don't have to actually do that. And so the firm that we utilized was the firm that had the most experience in this particular new area of the law with the bond financing without going to the voters.
J.P. Madison.
I just want to be really clear that this court was not told before it voted on this project about these expenses. We were never informed there would be any type of legal fee associated with what we were voting on. Even if the amount was unknown, I would have liked a heads up. Hey, we've got some lawyer bills that we're going to have to pay. I also think that it's the responsibility of a department when they're about to undertake a project to at least attempt to plan in their budget for expenses. Buildings and Grounds has a large budget. They worked on this project for a very long time. I don't think that it's good business to be spending taxpayer dollars by asking for forgiveness rather than permission. And that's what seems to have become a practice that concerns me. We were informed of these expenses after they had been committed and after we are obligated to pay. So we feel like we're faced with having to pay them or be sued. That's not the way that budgetary processes work. It's not the way the legislative branch of government should be treated. So I do appreciate the additional information from our attorney.
J.P. Pond.
I'll be voting for this. We have to pay our bills. The upside of this is because it was not included in the loan, we don't have to pay interest on it. I voted against the ordinance because I don't like to be rushed on something like that. And there's always unforeseen consequences, unintended consequences that you find out about later. The majority of the court voted for this to get that interest rate. And like I said, I didn't vote for it, but I'm all for keeping our bills paid. So I'll vote for this ordinance to make it good. I really don't understand quibbling over whether it got included in the loan, so we'd have to pay interest on this fee also. Thank you.
Thank you, J.P. Pond. J.P. Bowman.
Thank you, Judge. You know, one of the things I think we have to recognize, we were given a document with about 85 pages of fine print of all kinds of legal descriptions about what's going to be happening. And to think that we're going to sit here and all understand every aspect of that doggone 85-pound contract, 85-page contract is really just it seemed like 85 pounds. But anyway, to assume that we're going to all understand every specific in that doggone 85-pound contract is a pound again, isn't it? That's a heavy contract. But to believe we're going to all understand every aspect of that contract is not really very it's not very appropriate. So I think we got to go and move on with this thing. I'll be voting for it.
Any other discussion? Public comments? Public comments. All right, Ms. Patty.
Willie Lemming. Ann Harbison. Butch Pond.
Yes.
Lance Johnson.
Yes.
Susan Cunningham. Harvey Bowman. Judith Yanez. Patrick Deakins.
Yes.
Lisa Ecke. Sam Duncan.
Yes.
Eva Madison.
No.
Andrea Jenkins.
No.
Suki Hires.
No.
Sue Madison.
No.
We'll go into the second reading. The next
So we'll move to the second reading.
Can I back up and vote yes?
You have to,
Making a motion.
I move we take it to a second reading. Suspend the rules and
you got a motion to suspend the rules to go to the second reading.
Order. I believe that has to be done by somebody that voted no, does it not?
All you guys,
Oh, okay, I
No.
see. You're just going to a regular second reading.
You can, so.
Thank you. All right.
Somebody in the minority can ask for a, oh my gosh, I lost my train of thought here. Sorry. Reconsideration, yes, sorry, to reconsider. But it has to be someone in the minority that does that, and then there has to be a majority, a majority of 10 vote to reconsider, and then you can reconsider, or you can pass it on to a second reading. You have those two options.
Yeah, so, but it wasn't
Yeah,
been.
there is a motion on the floor.
Yeah, so we had a motion to go to the second read, J.P. Johnson.
Judge, could I ask my colleagues to use the microphones when they talk?
Please do that. You got a motion on the floor to go to a second reading, and who's here to second? No, do we have a second? We have a second by Andrea J.P. Jenkins. All in favor? Aye. All right. Any opposed? All right, we'll go ahead and, second reading reads by,
An ordinance appropriating $24,518.50 in the Quorum Court budget for 2019.
Ms. Patty?
Nope, we're only on second
Oh,
reading.
got it.
You'd have to go to a
Third.
Move to suspend the rules and advances to the third and final reading.
Motion goes to the third reading, a second. All in favor? Aye. Those opposed?
No.
All right. Go ahead, Ms. Patty.
No.
Oh, got to read it again, I'm sorry.
An ordinance appropriating $24,518.50 in the Quorum Court budget for 2019.
Public comments? Or any other discussion here? Public comments? Ms. Patty? Go ahead, J.P. Lemming.
I just want you to know that I voted no for this Johnson Control because it's never going to save the county any money. All these folks voted for it, now they're fighting against it. I'm going to vote to pay this bill and get this show on the road. But this $24,000 is nothing to what y'all's going to have to pay here in about 28th day of May of next year. You're going to have about $500,000 deficit you're going to have to come up with. So why argue over $24,000? That's my take on this. Thank you.
J.P. Ecke, you've made the motion for the third read.
Motion to pass.
Second.
Ms. Well, we had public comments. Any other body? Public comments? All right, Ms. Patty.
Willie Lemming.
Yes.
Oh, my goodness, just a minute. Got the wrong one. Okay. Willie Lemming.
Yes.
Ann Harbison.
Yes.
Butch Pond.
Yes.
Lance Johnson.
Yes.
Susan Cunningham.
Yes.
Harvey Bowman.
Yes.
Judith Yanez. Patrick Deacons.
Yes.
Lisa Ecke.
Yes.
Sam Duncan.
Yes.
Eva Madison.
No.
Andrea Jenkins.
No.
Suki Hires.
No.
Sue Madison.
Is that passes? That ordinance passed. Item number 10, J.P. Harbison. Hit your mic.
Attorney Lester, would you please read the title to 11, to number
10.1.
10.1.
A resolution encouraging all criminal justice agencies throughout Washington County to adopt the principle that no person should be detained in the Washington County Detention Center awaiting trial solely because of their inability to obtain pretrial release through traditional bail or bond.
Okay, our ombudsman, Dr. Edelman, asked for this resolution. He feels that for him to be effective with the criminal justice system, that the court needs to say that they're in favor of him helping to release people that do not have the means to pay the bail. I move that we pass 10.1.
Second.
We got a motion and a second. Any other discussion? J.P. Ecke.
Thank you, Judge. I have to go on record to saying that this is discrimination at its highest. Justice is supposed to be blind. It is indiscriminate of economic background, race, creed, or color. If you rape a woman or a man, and the sentence is, it doesn't matter if you're poor or not. That's the sentence. It doesn't matter if you do a crime. I can go on and on with all these other crimes. But what he's saying is because you are poor and you can't bail out, which is a percentage, it's only 10% you have to pay, We'll forgive that because you know what? It's okay. You're poor. I have a hard time with that. And I know other people will make an argument for this. But justice should be blind. And if you're poor and you're going to commit a crime, then you have to be willing to accept the penalty for that crime, just like everybody else. So that is why I'm against it, because it discriminates against other people for having means, for having maybe family. And there's a lot of times that people are left in jail because they are poor by their family members, because the family members are just downright tired of bailing them out in their third or fourth offense. This is nonsensical. Let's just bring common sense into the judgments that we're going to pass. This is why I'm against this resolution. It discriminates against other people. Thank you.
J.P. Madison and then J.P. Hires.
Thank you, Judge. So one of the foundations of our justice system is the notion of innocent until proven guilty. And one of the, if you'll look in the caption of this ordinance, we're talking about pretrial detainees. So that means someone that has only been charged and has not been convicted. And believe it or not, sometimes people are charged with crimes and then they're not convicted. Charges get dropped. There was last week, 2 individuals went up for aggravated assault, and the judge threw out the charges because there was not sufficient evidence after a jury had been impaneled. So those individuals were pretrial detainees, and they are not convicted of anything at this point in time. And so what Professor Edelman is saying is that for him to fulfill his obligation to help us get pretrial folks out of the jail is that if somebody, the only reason they're stuck down there pre-trial before any conviction is because they can't pay, then let's find a way to help them and get out of that situation. Because if they're down there in jail, they cost us money. Healthcare costs, detention costs, they put our law enforcement officers at risk. And so if you believe in innocent until proven guilty, you absolutely should support this resolution. So I will be supporting this fully. Thank you, Judge.
J.P. Hires.
Thank you. I agree with J.P. Madison, and we are talking about people who are pretrial who have not been convicted of anything. And I would say that cash bail systems discriminate against people who do live in poverty, because a wealthy person can bail out of jail and someone who does not have the means is not able to. And in addition to the cost to the county of incarcerating people who have not been convicted of a crime, we're also costing society in a lot of ways. We're talking about people can't go to work because they're in jail. People are not able to support their children, which puts a burden on our foster care system. And so I see this in a very different light, and I will absolutely be supporting this ordinance. Thank you, or this resolution. Thank you.
Any other discussion? J.P. Yanez.
So bringing it back to what we do at the court, our budget, and making it unbiased right now, what is the cost that we have for these pretrial individuals? Do we have that number? That cannot be released on bail?
The daily fee?
It's about $63.12 a day.
But do we have an overall cost of what it costs the county to keep them in jail? But like right now, currently?
Well, go ahead. I don't have it.
I just want to have that
Yeah.
discussion, just bringing it back to what we actually do here in the court, saving us money.
Do you have an answer to her question? You want to name the
Yes,
comment? Okay,
I
what's
would
the-
like to answer that question.
Okay.
We have over, or right at, anywhere from 350 to 400 pre-trial people in jail. That's running about, now, how many of these people are there because they don't have the funds to bail out? They all could bail out. Well, most, 90% of them could bail out, okay? So, we're looking somewhere like $25,000 a day is what we're spending at the jail on pre-trial people.
Okay.
And this is why I've been working for a long time on trying to get these pre-trial, haven't been convicted. Some of those, yes. Out of that 400, we might have 20 that should not be released because they are a threat to the safety of our community. But
JP,
anyway, this
So-
is why I support this.
We just calculated 24,852 a day. And so if we have how many that are, should be bailing out but can't, what was that number again?
There's 400 pretrial, 350 to 400 pretrial people in the county jail every day. So, you know,
And about 10% can't bail out, maybe?
well,
that'll be-
no, well, they all should bail out and they don't.
Depending on the percentage in 350 to 400. It's, I mean, the rough math, 1,800 to 2,500, if 10% is the real number, and if it's between 350 and 400. So $1,800 a day to $2,500 a day is the answer.
And the cost of the project is, I think we're budgeting 12,000 for,
This isn't to approve the project, this is just to approve the resolution,
So I
which
mean,
supports the project.
I think it'll save us money by doing this. That's the whole point.
Okay.
Thank you.
Any other discussion? JP Bowman.
Thank you, Judge. You know, as I looked at this thing, I didn't think it was even appropriate to put the thing out here, because I know the sheriff is releasing, or the sheriff and the judges are releasing like 200 people a month that they feel is not high-risk people. And I'm sure that some of these would be under that category. The other thing we got going on with this retention is the drug tests are taking so long to get done. And we're supposed to be getting some relief from that right away, because the lab in Lowell is supposed to open up here within a month or so. And that's been a major drag on why we have so many people down there. So I'm going to support this doggone thing because the Osmond one have asked for it, and we know that the enforcement people down there are doing everything they can to minimize the problem. So I'm going to support it even though I don't think it's necessary. Thank you.
Public comments? Any public comments?
Mr. Chairman,
JP Madison.
I just have a technical issue. I need to acknowledge and confess that I think my original motion was to read all ordinances tonight by title only, so I'd now like to make an additional motion that we read resolutions by title only tonight. I don't want us to get in trouble.
No, right. We did.
My original motion just said read the
All right.
ordinances by title
All
only.
right.
And I should have said ordinances and
Before we
resolutions.
vote, I'll have to make sure he reads that. Okay.
No, get a second, let her vote. Oh, yeah, we'll get to
So
that.
at some point,
Okay.
Okay, Beth Koger, Fayetteville. I'd just like to say I don't really understand how this discriminates against anybody, and I'd like to invite the court, if you haven't been, you should go to see some bond hearings on Monday morning, Wednesday morning, or Friday afternoon, and you will see that these people are there because they can't make a $1,500 bond, which means they don't have $150. I don't know anyone in jail who's there because they want to be there. And also, I want to remind the court that Sheriff Helder, he's here, he can speak for himself, but he spoke in favor of the ombudsman, very favorably. So I'd just like to remind you of that.
Thank you. Any other public comments? All right, we had a motion. I forget who had the motion.
JP Harbison.
JP Harbison made the motion. JP Jenkins made the second to approve the resolution. Now you looking to amend? You want your mom? Okay.
I would like to propose an amendment to the pending motion that it also include a suspension of the rules to read the resolution only by title. Can we do that? No, that won't
You
work.
have to do the.
Sorry. Lawyer failed.
No, no, it has to be a separate motion.
Okay, so go ahead.
Read the whole thing if you'd rather do that.
Go ahead. And I'll ask that on the front end.
Resolution encouraging all criminal justice agencies throughout Washington County to adopt the principle that no person should be detained in the Washington County Detention Center awaiting trial solely because of their inability to obtain pretrial release through traditional bail or bond. Whereas Washington County will begin utilizing the services of an ombudsman to help reduce overcrowding at the Washington County Detention Center, and whereas in order for the services of the ombudsman to be effective, the criminal justice agencies in Washington County must work together to ensure that no person is being detained in the Washington County Detention Center and awaiting trial solely because of their inability to obtain pretrial release through traditional bail or bond. Now therefore be it ordained or resolved by the Quorum Court of Washington County, Arkansas, Article 1, the Washington County Quorum Court encourages all criminal justice agencies throughout Washington County to adopt the principle that no person should be detained in the Washington County Detention Center awaiting trial solely because of their inability to obtain pretrial release through traditional bail bond.
Okay, so we got a motion and got a second. Ms. Patty?
Willie Lemming. Ann Harbison. Butch Vaughn. Lance Johnson. Susan Cunningham. Harvey Bowman. Judith Yanez. Patrick Deakins. Lisa Ecke. Sam Duncan. Eva Madison. Andrea Jenkins. Suki Hires. Sue Madison.
All right, that resolution does pass. Item 11, J.P. Deakins.
Thank you, Judge. County Attorney Lester, will you read this by title only, please?
An ordinance to establish the daily fee charged to municipalities for housing prisoners in the county jail.
Thank you very much. So, as we are all well aware on this court, we've had many challenges to tackle with our jail. And I think we're making great progress. But tonight, my goal is to tackle the funding issue for our current operations. The deficit in our jail's budget has been an issue for many years now. And in fact, if you go back and I just pulled the last 5 years, it's running about $1 million a year as a deficit. And I believe this is detrimental to the county as a whole. So this ordinance establishes a daily use fee based upon audit figures provided by the Sheriff's Department. I want to remind everybody on the court that our authority is to set the use fee through ordinance. It's the judge's power, the judge's office, to contract with municipalities to charge or to raise funds for the jail in other ways. I do not want to charge a daily fee to our municipalities. That is not the goal with this ordinance. I've had several conversations with mayors and city leaders. What I want to do is honor the requests of those leaders and implement a per capita fee funding solution achieved through contract, which would be written by the judge. This fee will only become actionable if the municipality decides to opt out of the contracted agreement with the county. I invite all the cities and municipalities to participate with our county to alleviate our funding issue, and they've done a great job and they've been great partners on many issues up until this point. However, I believe this ordinance is needed. It will bring certainty to the county if a municipality drops out or opts out of a contract, and this will provide funding to us in our budget by law. The judge and the county attorney, through my conversations, have both committed to work with the municipalities to see contracts are fair and reflect the needs of the county. Drafts of these agreements will be available as soon as we get determined numbers from Treasurer Hill. I feel like we've listened to input from all parties, and I feel this is the best issue, the best solution to a very tough issue for us all. It's a very tough issue to vote on things like this. And finally, I believe that this is time sensitive because the cities are going through the exact same process that we're doing right now, and that's a budget process, and they need some certainty. So for all those reasons, I move that we suspend the rules and take this ordinance to the second reading. Thank you very much, Judge.
We got a motion, and we got a motion to adopt the ordinance, a second. Discussion, J.P. Madison, and then J.P. Harbison, and then J.P. Madison.
I'm going to vote against moving this to second reading because I really think we need to slow this process down a little bit, not because we haven't been talking about it for a long time, but because I don't think we've given our cities a chance to actually work on a contract. So this issue has been talked about, and I think that most mayors and police chiefs went to a meeting where they walked away under the impression that there would be some type of per capita fee. And I think that's what everybody thought was fair. The problem is that we as a court don't have the power to impose that kind of fee. Only the judge can do that. I think that what our cities are facing right now is, why is the Quorum Court coming down with this sort of seemingly punitive measure when we haven't even seen the interlocal that we're being asked to enter into? And I feel like it's sort of a poor negotiating tactic to say to our cities, well, hey, this is what we're going to do to you if you don't sign off on this agreement that you don't know what it is yet. So let the city see the interlocal, let them see what we're proposing, and I bet most of them are going to agree to it, and this can be sort of an afterthought. I just don't think it's a nice way to treat our cities to sort of force this issue on them without knowing what the alternative is. And my concern for my city, since I'm entirely within the city of Fayetteville, is what is the deal that's going to be offered to my citizens? What is the per capita rate? Is every city going to be offered the same rate? And so until I know those answers, I don't feel good about forcing something on the cities as a negotiating tactic with this unknown out there. So I wish we would slow down. There's nothing that says we have to pass this tonight because it doesn't even take effect until January 1 of 2020. So let's leave it on second reading. Let the judge and the county attorney draft the interlocal. Let the cities, and I know there's some folks here from cities here tonight, look at it, decide what to do, negotiate it, and then if there are cities that want to hold out, then we can talk about this as a solution. I just think this is not a good way to treat our cities. Thank you, Judge.
J.P. Harbison.
I was one of the people that, and Harvey, and I don't remember who else at the Quorum Court met with the mayors to discuss the funding of the jail. And we walked out of there with an agreement that it would be a per capita charge, but as a Quorum Court member, I have no control over that. And so it's up to the county judge to write this interlocal, and Brian, to write this interlocal agreement. At the end of the day, I think we probably need this ordinance, but I feel that the mayors feel that it's something that came completely out of the blue, and they were not aware of it. And I think they probably agree with us that there should be another option if they don't want to do the interlocal agreement. But I think the county judge needs to sit down with the mayors and get an interlocal agreement before we vote on this. So I will be voting against this. Thank you.
J.P. Madison.
Thank you, Mr. Judge. First, would it be all right if I asked the sponsor a question?
Deacons. They had a question.
Okay. On line 2223, it says, it defines prisoners of municipalities, and it says from the point of intake until charging on a felony offense. Do you know how long we're talking about, how long it takes from intake until charging on a felony offense?
I don't know that you could speak to one particular situation like that. I bet it varies by case to case. I welcome anybody to respond to that with some sort of average.
I believe our prosecuting attorney has previously said it can take up to 30 days. So that,
Shorter, longer, or just average? Go ahead.
Yeah, come to the mic.
While he's coming, this is only on a first reading, so really, the comment and all isn't necessary now until we get to a third reading, but just wanted to let the court know that.
It depends, but on average, I'd say about 30 days. That's when they're usually set for arraignment, is 30 days after they're arrested. And typically, charges get filed. It can be sooner. Obviously, this is for someone arrested on probable cause without a warrant, because if someone's arrested on pursuant to an arrest warrant, the charge has already been filed. So the fee wouldn't apply in those situations. But typically, it's going to be about 30 days from arrest until the information's filed.
Well, just don't run off. If, let me make sure I've got this right. So if let's say Fayetteville arrests somebody and it's 30 days until they're charged on a felony, Fayetteville will pay us for those 30 days.
Yes,
And then once they're charged on a felony, they're a state prisoner, and the state won't pay us
No.
anything.
No, once,
They have to be convicted.
they have to be convicted first. So once the felony information is filed, that's the charging document, then it becomes the county's responsibility. So there's no fee that will be brought in from anybody, city or state.
Okay, so do they have an opportunity to bond out before,
Oh, absolutely.
during that 30 days?
Yes.
Okay, so that might not be that.
So
okay.
they get arrested and they get a bond set typically the next day. So, you know, I don't know how much this is going to affect people who can't make bond.
Okay, the other question I had, thank you, was for Mr. Deacons. You said that this agreement that is supposed to happen between the judge and the municipalities, that the municipality could opt out at any time. Can the judge opt out at any time, or is this, does the opt-out apply only to the municipalities?
I would invite the judge or the county attorney to speak to that.
Oh,
Go ahead, Counsel.
Well, first, let me just say that the motion to pass this ordinance is an improper motion. You'll need to vote or to rule on that. As to your question, the opt-out, I mean, depending on the contract, the opt-out would be either party's option. This court has the ability to set a daily fee and thereby charge, and that's the only ability you have, is to set a daily fee. You don't have any ability to enter into an agreement with the municipalities. Only the judge can do that. And so if the county judge, whoever it may be, whenever it may be, decides to opt out or end these contracts, then it comes back to the court to say, are we going to continue to charge a daily fee, what that fee amount's going to be, if we are, or we get rid of the fee altogether. That will be completely up to the legislative branch. And so the legislative branch really has the ultimate control in this, because you have the ability, even if the judge or the cities don't opt out, to come in and say, you know, we're not doing that pro rata thing anymore. We're going to charge $5 a day per prisoner to every city from here on out, and that's what we're going to do. And that supersedes any contract that the judge would enter into with the city. So really,
do we anticipate that all municipalities will be charged the same rate?
it'll be per capita.
Okay.
It'll be based on their population. The daily rate has to be the same for all. The law says that you can set the daily rate up to the actual provable amount that it costs to house an inmate per day. You don't have to set it at the top. You can set it at 50 cents, so you can do whatever you want. But the Quorum Court gets to make that ultimate decision on all of that.
Okay.
Okay, so, all right, so we had a motion, but it's not a motion since it was on its first read. There's J.P. Johnson. J.P. Johnson.
Tuesday night, I spoke to both Chief Peters and Mayor Sprouse in Springdale. They're well aware of this ordinance. They know it's coming. They don't like it, but they know they have to pay their share. So not all of these folks are going to be surprised.
Okay.
J.P. Diggins, was it a motion to suspend, to move it to a second reading? Okay, we should not be having any debate, because that's non-debatable.
Yeah.
I'm sorry, I didn't catch that, or I would have said it earlier. No offense to the public or anybody, but when you have a motion to suspend, then it's not debatable. You have to take a vote on it right now.
All right, so,
No, you just need either a roll call or a voice vote, but you got to vote on the
so all in
motion
favor to move to
suspend.
suspend the rules, go to second read? All in favor? Those opposed? No. All right, Ms. Patty.
Willie Lemming. Ann Harbison. Butch Pond. Lance Johnson.
Yes.
Susan Cunningham. Harvey Bowman. Judith Yanez. Patrick Deacons.
Yes.
Lisa Ecke. Sam Duncan.
Yes.
Eva Madison.
No.
Andrea Jenkins. Suki Hires.
No.
And Sue Madison.
Okay, so we move on to the next item. It
All right, so it
The motion
fails. It'll go to the second at the next meeting. Item, that committee reports?
Yep.
J.P. Bowman, committee reports.
Thank you, sir. On July the 29th, the county services met, and we talked about an upgrade of the audio system. And you can see before you some of the things that's been done since that meeting, because we want to see audio on this side and overcome this small screen. So our building and ground has already taken care of that. I understand they've put out bids for additional consideration of this object, on this proposal, and we'll be hearing more about that soon. That's it.
All right. J.P. Harbison, Finance and Budget.
Mike?
Hit your mic.
We met on August the 6th. J.P. Johnson. Sorry. And we heard from Bobby Hill, our treasurer, risk management consultant, Nelson Driver, and Shannon Worthen, our controller. We had a discussion on the bond money for Johnson Control. It was approved. Joel Garner from Ozark Regional Transit made a pitch for some money of $5,777.20 to give his drivers a raise, and that failed. I hope he comes back. I think that's a worthwhile project. We had most all the other items that we discussed were on the consent agenda tonight. And Chief Gales gave an update of the Quorum Court audio upgrade. And there was a little bit of discussion of the upcoming budget meetings. So.
All right. Thank you, J.P. Harbison. J.P. Johnson.
Thank you, Judge. The Jail and Law Enforcement Committee met a week ago Monday. The report's in your packet. Thank you.
Personnel, J.P. Pine.
Yes, thank you, Judge. Personnel Committee met August 5th. The committee approved 2 requests from Circuit Clerk Kyle Sylvester to adjust the pay on 2 positions. Committee also approved to forward 2 requests from you, County Judge Joseph Wood, to the Finance and Budget Committee. Thank you.
Thank you, J.P. Pine. And with that,
Mr. Judge?
yes, ma'am.
Well, I did that just in time, I guess. I'd like to request, thank you for recognizing me, I'd like to request that the folks that spoke about Trace Branch get a written
We'll
update
visit with them.
on what's
visit
going to
with
happen
them.
with their road. And also, Mr. Mayfield, I believe his name was, that
I'll
asked
share
some
that. I'll visit
questions.
with
Could you share
Chief
that
Gales.
information with the JPs about where we are on the jail proposals?
Are you the J.P. that has that group?
Excuse me?
Are you the J.P. that has that group? Okay. All right.
I just
We'll follow
want to
that.
know.
Thank you.
Motion to adjourn.
Motion adjourned. Meeting adjourned.